and welcome to the Arbitration Conversation. So in this webisode, we're going to dive deep into looking at labor and employment arbitration in South Africa. And for that, we have an expert in the field who has done many arbitrations in South Africa and is South African herself from Cape Town, and that is Hilary Mofsowitz. And Hilary, she's here now in New York, but she had been in Cape Town for many years doing labor and employment arbitration, but also serving as a mentor to other arbitrators and mediators in the field. So it's really a distinct pleasure to talk with you today, Hilary. I know you're certified in many different areas of labor and employment arbitration and are truly an expert in the field. So thank you so much for being here.
Thank you. Thank you very much. It's lovely to be here.
So let's kind of just start off. What are some of the, to kind of get our bearings, especially thinking about the differences. What differences are there, would you say, between arbitration, especially labor and employment, in the U.S. versus the practice in South Africa?
Okay, so I think to understand the South African situation, and then, we can look at some of the major differences, but one has to understand that our labor laws, our labor legislations are very new, probably compared to other countries of the world. And that has to be seen against the context of the big change that the country went through in about 1995, when we moved from the old apartheid government to a democratic government. So at the time, everything had to change, and obviously labor legislation was part of that change. So the drafters at the time studied various dispensations all over the world, and the South African labor laws are very much aligned with Australian and to some extent Canadian law, and what was done is that the right to fair labor practice is enshrined in our labor legislation. So what I've understood, and I'm no expert on the American system, is that it irrespective of a person's contract of employment, irrespective of the wording of a collective agreement, the right to fair labor practice, the right not to be unfairly discharged, or what we call dismissed, is enshrined in the law. So it's not up to negotiation at the time that a person commences employment with a particular employer. So because of that, I think the access to justice is perhaps more easy to every person who finds themselves in a situation where they need some support and assistance. So what was done at the time when the Labor Relations Act was promulgated and amended was that a body was formed called the Commission for Conciliation, Mediation and Arbitration. And predominantly all labor disputes in the private sector, with some exceptions, are heard through this. It's like a court in that the decisions taken are legally binding, but it's referred to as a court of equity as opposed to a court of law. But all employees, without having to pay for the service, has the right to have their case mediated, which is always the first step, and then arbitrated at no cost. And I think the process of arbitration, when it comes to arbitration, is probably very similar to what you have here. But I think the access is different, and I think the rights to not be unfairly terminated or not be subject to an unfair labor practice is enshrined in the law, irrespective of a person's contract or a collective agreement.
Well, and it depends, of course, in the U.S., there's a difference we actually make a distinction with labor versus employment law. So there are labor laws that are specific to unions and unionized labor. Is there any distinction in South Africa between unionized labor and other employment?
So basically, an employee has the right to join a trade union, etc., and there's some organizational rights and legislation around that. But the right to an arbitration is a right that every employee has, irrespective whether he or she is a member of a trade union. So an employee can come to this court and represent himself or herself, or if that person is a member of a trade union, and then obviously his trade union will assist him. But he does not have, there's no right that a trade union member would have that a non-trade union member wouldn't have.
With respect to arbitration.
Yes, yes.
So I'm wondering, the process itself, though, is the process itself private or public?
So basically, the actual process of arbitration is an open court, and I imagine the laws of evidence and the calling of witnesses and cross-examination of witnesses and so on, I imagine is pretty much the same. I have a sense that ours may be more formal than yours, although I can't be sure. And I think that the arbitrator will adapt it depending on the level of the dispute. So if it's a higher level employee who's represented, the parties are represented by attorneys, I imagine the arbitrator will conduct the process far more formally. We record our proceedings, etc., etc. But if it's a lower level employee who's perhaps representing himself, the arbitrator would probably run the case far more simplified with the limited technicalities, as long as the laws of natural justice are applied. So
is it actually I guess then isn't it really, if it is a public court, essentially, isn't it just court? I mean, isn't it basically litigation then, going to a public court? Because usually when we think about arbitrations in the US, you're usually talking about a private arbitrator in a private process. So this sounds very much more like maybe just a labor court. Is it more along those lines?
It's like a labor court, except that we also have a labor court. So the decision of the arbitrator, and we're called commissioners. So the decision of the commissioner but who runs an arbitration is a legally binding decision. But that decision can be taken on review to the labor court, which is a high court. But it specializes in labor. It's not a civil, doesn't hear civil matters. So we have specialized labor courts. So the Commission for Conciliation, Mediation, Arbitration is like a court, but we call it a court of equity. Although the decisions are legally binding on the parties and can only be changed on a successful review.
So do they also have private arbitrations ever as well, or they do as well?
So certain big organizations can have a private arbitration clause with their employees, provided the employee is not in any way disadvantaged by that, because in law he has the right to a free arbitration. So an employer may choose a private dispute resolution forum as long as the employee is not disadvantaged by that. And
do very many companies do that? Because if you have the access to essentially what would be a free public court, really a regular labor, just a regular court, then it seems as though wouldn't they use that route because that would be less expensive for the company?
There are companies that prefer private arbitration, and those are normally the bigger corporations or the state-owned companies. But the majority of companies use the public court, so to say. So we differentiate between, and I think you do that here, public and private. So the public sector, which is the state as the employer, which is a huge employer, would be your Department of Education or Department of Health. They have their own councils or their own courts. And then private would have their own. And and then, of course, some companies have their own private clause where they can use a private arbitrator through a dispute, an alternative dispute resolution forum. So I don't know if it sounds very confusing or if I'm making it more simple, I don't know. But basically, I think it's different in probably in that respect.
Well, yeah, because it sounds like it's, well, there's a lot of different type of proceedings, many of which are really, it sounds like public courts, but just specialized courts in the different areas. So I'm wondering, do you have a view as to what do most employees prefer? Do they prefer these private processes or the public processes?
No, I think generally I think employees have more trust where it's public and they don't feel that their employer has any say over it in terms of the appointment of the arbitrator, as an example. So
that's what I would, yeah.
But it can vary with the level of employees and when attorneys get involved and so on and so on. Then I think that it is a good system, the private arbitration. But in our general courts, we deal with all level of employees. We deal with lower paid employees up to senior managers, directors, etc., etc. So the court has no hesitation in dealing with those kind of matters. And then we also deal with discrimination in our labor courts, as opposed to, I think here what I picked up is a more civil matter. So if an employee, we have subsequent to our main labor Relations Act being promulgated, we have other acts like the Employment Equity Act, where an applicant for employment or an employee who alleges discrimination can have his or her case heard through this public forum as well, as opposed to having to approach a civil court.
So who are the judges? Are the judges in these cases, how do you become, is that what you were, then were you essentially a labor judge in these proceedings?
Yeah, well, yes, like a judge, but as I say, we're not called judges, we're called commissioners. So, but it basically is the same in that, you hear the case and you make a decision which is legally binding. It's subject to review to the High Court, so it's not an appeal, it's a review, and then above the labor court is a labor appeal court, and then the last court of the land is the constitutional court. So a matter can go, as far as the constitutional court, and they sometimes do. But it is, you hear a court, it's a office in all the different major towns of the country where the commissioners are highly regarded, and commissioners are, we work predominantly as independents and not as employees. And for example, you would give your days that you're available, and the days that you're available, they will assign a case to you in line with your expertise and level. So we have junior, intermediary, and senior commissioners. So
interesting. How often do the commissioners also mediate the disputes ever, or is that somebody else who then handles mediation?
Both. So basically, some cases are scheduled only for mediation, and then generally they tend to use more the junior commissioners. But the law also provides that once, let's assume the case is not resolved as mediation and it's then scheduled for arbitration at some later date, and normally arbitration takes place within about 2 months from the case having been lodged. So it's pretty quick and efficient. But the arbitrator then may, and it says this in the law, the arbitrator may, with the consent of the parties, revert the arbitration back to mediation. And we find that we settle, somehow or other the arbitrator settles a lot of the cases. So the last statistic that I looked at for, I think it was the year 2018 to 2019, was something like 55% of cases were settled at arbitration that obviously hadn't settled at the mediation.
That's interesting. So basically you do a med-arb-med. So it's a mediation, goes to arbitration, and then goes back to mediation.
Well, we have a mediation, which we call conciliation, but it's basically the same thing. So we have compulsory mediation. So all cases must be scheduled for mediation before they can be scheduled for an arbitration. The parties don't have to attend. So you don't lose your right to arbitration if you don't attend, but you have the right to go through that process. You're offered that right to go through that process before your arbitration. Then we have something which I think is similar to what you have, is a med-arb, which is a different animal, where the matter is scheduled for both on the same day, one after one process directly after the other, where the same commissioner will mediate it, and if it's unresolved, will start the arbitration immediately. And then that is then different to an arbitrator, where the matter hasn't been resolved in any previous process and it's scheduled for arbitration, where the arbitrator can convert it back to a mediation with the consent of the parties. And arbitrators tend to be robust, and my settlement rate is over 80%, 85% or something like that. So we work very hard, and I think we get more involved in the mediation than you might find here, and somehow we get away with it. It's quite a fine line if you're the person that's supposed to arbitrate the matter, how involved you can get. So,
well, the tough part, I guess, and one of the main concerns about this idea where the same individual is both a mediator and an arbitrator in a case, is that mediators often become privy to information, especially if there's any sort of caucusing involved, that you wouldn't necessarily want an arbitrator to know. I don't know if that ends up being a problem in this process.
At the end of the day, it could be, and I think that the person, the commissioner knows that she's mediating and arbitrating. I think personally that mediation is a different kind of mediation if you're only the mediator. And I think you have to have a sensitivity around that.
Yeah.
But the mediation arbitration process, where the matter is scheduled for one following the other with the same commissioner, the parties can object to that. So there is a right in law to lodge an objection to the one process following the other immediately. And you don't have to have a reason, you just have to follow a process, you have to notify the other side, it has to be done within a certain amount of time, and then then the matters will be separated. But then when the matter is scheduled for arbitration, then you'll find many of our arbitrators settle the case as well. So I don't know what the percentage of settlement is here, and I suppose it varies in the private and the public sector. Public sector, you probably don't settle nearly as much as you would in the private sector.
Yeah, it depends, I think, on a lot of things. Well, and then, of course, a lot of the information is private, because arbitrations here are not open court. Even in the labor setting, they're still private. So that means, not everyone's invited in. So, and a lot of times with settlements, you don't know exactly when or how something was settled, because again, settlements are often private as well. So, so it's difficult to get that sort of data. So it's interesting. But it sounds very, especially with it being a very active element with the mediation and arbitration. But I will say, I know here as well, though, there are very many settlements that do occur after an arbitration has been filed, right? And it's kind of, that can happen at various points. But if it's a straight arbitration, it's very unlikely. The arbitrator would probably not be taking a very active role in bringing that settlement together. They might, nudge it along by promoting discussions, right? or sort of tipping their hat to some way or the other during the course of maybe when evidence is presented, or during a preliminary hearing, maybe suggest that, well, it looks like this could, you know, be something that should maybe be settled. But anything further than that would probably be pretty rare, unless you actually have an arbitrator who you want to have as both a mediator and an arbitrator through a med-arb type process, which does happen here as well, and is possible. So, but as we were talking about on the evidentiary and the confidentiality questions, that can sometimes be a concern to parties.
Oh no, I think one has to be very sensitive around those issues. I did a big case, well, so our arbitrations are public hearings. I did a big case where an employee of the parliament had been terminated, a very, very senior employee, and I was inundated with the press, and it was just a whole mess. And as soon as I could smell that the attorneys, the parties wanted to talk settlement, I just threw everybody out because you know, you can't compromise. You know, those are private talks. Had the matter run, you know, a formal arbitration, it would have been different. I would, you know, to throw somebody out, I would have had to hear an application of what the prejudice was to have that person in and so on. But if I smell that there's going to be a settlement, then everybody wants to say,
everybody else. Yeah. And you know, I do have a lot of so as I told you, you know, I did teach comparative dispute resolution in Cape Town at University of Western Cape, UWC, there in Cape Town, and some of my students did have internships with the commission, as you know.
yes.
So I've heard some about these different processes. And I think at the end of the day, what we're talking about in any country and in any sort of, we're just looking at different ways to solve problems, right? I mean, that's really what dispute resolution, arbitration is just another tool. Public trials are another tool. Mediation is another tool. Conciliation is another tool. And these are all just tools that we have in our toolbox, and sometimes different tools are needed, and sometimes maybe it's promoting settlement and getting people to sort of think about what their best outcome could be for themselves and their families. So it's important stuff. Well, gosh, Hilary, I really appreciate your taking the time. It's really great to talk with you, and good luck, and enjoy New York.
Thank you very much. Thank you very much. It was lovely talking to you too. Thank you.
Definitely.